when they're collecting biometrics in Brazil?
Sure. So, Lindsay, I would say that here in Brazil, in the world, the processing of biometric data that affects vulnerable populations, restricts services, or involves surveillance in public spaces is generally regarded in Brazil as high, therefore requires stronger safeguards, greater transparency, accountability measures. I would bring first case a larger scale facial recognition in public spaces. This has been a topic of discussion here. You know how we are crazy about carnival, and we have implemented facial recognition in big events, and this concerns about mass surveillance, discrimination against vulnerable groups, and the using biometrics for public safety. A second use that I would bring would be the for access to essential public. So as from this year, we have a recent regulation that makes it the use of biometrics for social security seen as high risk because individuals may not have a real choice. This intensifies the it's about voluntary inclusion risks and the need for strong safeguards against errors or false negatives. A third case, I think private sector authentication systems involving minors or vulnerable individuals. For instance, we have recent legislation that obliges bets to use biometrics, age, and also verifying players that can do it too. And this creates concern for collection, storage security, and the potential for secondary uses. Another biometric controls. So using biometrics for timekeeping, access control, or performance monitoring. This is very controversial because the consent is freely given in employment relations as if tracking is really high. And finally, although this is really still early, I would bring discussions involving the neurotechnology. So this raises concerns about future systems that could capture or infer neural patterns, be considered high risk because it touches mental privacy and cognitive autonomy.
Okay, yeah, lots of interesting issues there. How about in Mexico, Isabel? Are there any use cases that would give rise to special issues in your country?
Yeah, I mean, I could be really brief because I could say same thing as Luiza, but I would go after her examples and tell the reality in our country. For example, the first one that she was giving in soccer stadiums, we have this huge case last year. In fact, it was the last one that the previous authority ruled and it was. I mean, in Mexico, the authority ruled that there could be an exception to use this biometric data to access to the stadiums because we have in two cases, two really dangerous and violent cases in these soccer stadiums, and so the Data Privacy Authority authorized the use of these devices and these biometric data to access the stadium under center conditions. But once it was authorized, the authority found and is still an undergoing process that the league was not processing the data in accordance to what was agreed, no, in terms of what we have been discussing, no, proportionality and proportionality and use and purpose of the processing. Second, I think it was we are now dealing with a new identity card in a national level, and it's gonna have mandatory biometrics. But the main problem is that the use of this biometric data is intended to be at disposal of certain police authority, and that's under a really big controversy right now. Of course, the vulnerable parts of the population, not only the minors, but all these work-related actions that Luiza was mentioning as well. And in our cases, even we don't have this the legitimate interest basis for processing data, because we are under consent regime. But all these work-related processings are under the scope of the authority as well. For example, in terms of the vulnerable populations and not vulnerable, another case that last year was really public was in relation with online exams and all the technologies that are used to follow the student when they are doing these online exams, and how it can lead to non-proportional processings. And finally, in relation to the neurotech and the controversy of this, as I was mentioning in my previous participation, we are now under the scope of a new authority, which is supposed to be issuing a new law in the beginning of the new year. And although there's a lot of secrecy around the processing of the issue of this law, we have been told that the neurotechnologies issue are one of the chapters that are going to be under the scope of the law, in terms of if they are considered or not biometrics as well.
Okay, well, it's a large world, but when it comes to privacy, a bit of a small world, because there's so much overlap, I think, between our three countries and the focus of the regulators. When it comes to Canada, there's three areas that I thought I would highlight today, mainly because there's been recent or significant guidance issued on these topics. Some of the issues like neurotechnology that were raised by my friends here are certainly big privacy topics, but we don't have a lot in terms of concrete guidance. So the areas that I would highlight for Canada are use of biometrics in the retail sector, in the employment context, and by law enforcement. So again, you'll hear some overlaps with what Luiza and Isabel were talking about. In the retail sector, a number of use cases have emerged, including cameras that use facial recognition technology for security and loss prevention purposes, such as to identify known shoplifters, but also cameras that are being used just to estimate certain demographic information about shoppers, like their age and their gender, primarily for marketing purposes and analytics, but without trying to connect the information to an identifiable individual. Overall, organizations using these technologies have encountered a number of challenges in Canada, with several cases indicating that express consent is needed to collect and use individuals' personal information in this context. Now, of course, given the low likelihood that individuals are going to provide their consent to this, this raises an issue about whether organizations can realistically use these technologies in Canada at all. And again, this goes to the fact that Canada is a consent-only regime. Like Mexico, we do not have legitimate interests. In the employment context, one of the common use cases already flagged by Luiza is systems that are used for attendance and timekeeping purposes, such as fingerprint time clocks. In some jurisdictions, like here in Ontario, where I'm located, there's actually a statutory gap when it comes to processing employee personal information for provincially regulated employers. So this does allow more flexibility to use these types of technologies. But in other provinces like Quebec, where there is applicable legislation, employers have to be cautious about using these technologies. And overall, the regulators tend to view this processing of biometric information quite negatively. At a minimum, employees should have a meaningful choice as to whether they will allow their employer to process their biometric information. So, for example, individuals who don't want to use their fingerprint to clock in and clock out could be given a unique code to log their attendance at work. But the Quebec regulator takes a particularly strong stance when it comes to this technology, and it's actually issued specific guidance on the topic of biometric time clocks, which indicates that in the vast majority of cases, this processing of personal biometric information is not permissible at all under Quebec laws. Again, even with consent, you must have a serious and legitimate purpose to process personal information in Quebec. Still, the factual circumstances are relevant to whether and how biometric information about employees can be processed. So I would strongly recommend that you obtain legal advice before you purchase a biometric system that's intended to process Canadian employee biometric data, especially if it's intended to be used for timekeeping and attendance tracking in Quebec, given the strict approach taken in that jurisdiction. Finally, as has also been mentioned, I think both by Luiza and Isabel, there's been a number of cases and guidelines that have been issued in Canada with respect to the use of facial recognition and other biometrics by law enforcement and other government authorities. I would say this issue is really too complex to address in any helpful way in the short time available to us. So for now, I'm just going to flag that this is also an area of risk for Canada, and our audience should be aware that there are significant guidelines and limitations, including when an organization is offering biometric products or services that are intended to be sold to law enforcement agencies in Canada. So feel free to reach out to me if you need guidance on this topic. But for now, to wrap up our session, we thought it would be helpful to highlight some of the key cases that organizations should be aware of in each of our countries if they're processing or intend to process biometric data. I think this time we'll start with Isabel. So are there any key cases that you would like to highlight for Mexico?
Well, I mean, the ones that we have mentioned, no, Lindsay, I mean, the key cases, if you are going to process a personal data related to biometric data in terms of war-related issues, in terms of vulnerable population, in terms of mass surveillance, in terms of, no, I mean, what I would like to highlight to wrap up, and congratulations for the great moderation, Lindsay, and the great wrap-up that you did in the first place of our participations, is that we have a similar approach. Although, I mean, I would like to rescue what you mentioned. Do not stop at the regulation. Go for the opinions and the guidance of the authorities, which have a much more broad scope, and it's gonna let you know how the authorities dealing with these cases. No, so review the guidance, not only the statute as you were mentioning, and the other point is, and I think Luiza was mentioning at the first place, is that we have to, at least in Mexico, we have to. There's no such a constraint or narrow definition of what a biometric is. So you have to be. I mean, we've been dealing in the past of if a digital print is a biometric data or not, or if not only that, which is of course a fingerprint, but if the facial recognition, what's in place, the template or not the template of what you are processing. So that would be a second point. And overall, what happens with biometric data, as well as it happens with sensitive data, is that whenever you are dealing with this data in terms of Mexican legislation would imply that they can cause an irreversible harm or to the individual and to the data subject, no? You have to notice, and you have to take into account that any principle or any obligation of the law is going to be more strict when you are dealing with this data. So if you need the consent, you're going to be required to have a more strict consent, as you were mentioned. Proportionality is always like in terms of every processing of data is the key of the processing, and you're going to have to be to fulfill with all these principles or regulations. For example, the security measures are going to be stricter when dealing with this kind of data.
All right. Well, thank you for those key takeaways. Luiza, are there any specific cases or decisions issued by any of the regulators or courts in Brazil that our audience should particularly be aware of?
Sure. So I've selected a few, but in benefit of the time, I'll bring the biggest one, the one brought the biggest issue here in Brazil, the most debated one, involved tools for humanity. So this is a company. So it's the individuals iris biometrics in exchange of digital tokens. So what they did was they had those little in shopping malls, very popular in Brazil, and they offered um, digital tokens, which to money to the population in order to collect the iris. So this generated lots of controversies, as in due to the disproportionate collection of highly sensitive, insufficient transparency about how the biometric templates used would be stored, and of course, make vulnerability of most of the participants who were incentivized by biometrics for financial reward. So several consumer protection authorities and the NPD, our DPA, open investigations questioning whether consent was really freely given, and of course it wasn't, and whether the processing complied with the LGPD, our General Data Protection Laws, principles of necessity, purpose, limitation, and data minimization. So this case became a central example in Brazil for the big debate on high-risk biometric practices. The ANPD released many documents on the matter, issued a decision to perform several obligations. Otherwise, they would suffer a big penalty. And this is really this is the best guide that the best guidance that companies have today on what regulators really expect for companies to perform when processing biometrics data. For example, the transparency measures that be implemented, how the data should be stored. So this is, although, as I said to you, we do not have specific on the matter yet. We do have this decision that is the biggest guidance that we have on this moment, and in this case, because this is our most emblematic case on this matter.
Wow, that sounds like a fascinating case. I want to read it myself. I don't know if it's available in English, but it sounds really interesting. So I guess that brings us back to Canada again. Now, one of the most recent cases in Canada that has implications for processing biometrics is the joint investigation of TikTok by the Privacy Commissioner of Canada and its provincial counterparts in Alberta, Quebec, and British Columbia. A key finding in this case, which I think departs from the approach to biometrics in at least some other countries, is that the regulators found that biometric information does not need to be uniquely identifying for it to be considered sensitive personal information under Canadian privacy laws. So in this case, TikTok used facial analysis technology to estimate the age and gender of persons in videos that were uploaded to its platform for the purpose of categorizing the videos for recommendations and targeting. So in other words, TikTok was using the data to determine whether a video would be included or excluded from other users' feeds based on their interests. The regulators found no evidence that TikTok was analyzing facial features in order to identify or authenticate a unique individual. And they also accepted TikTok's assertion that its computer vision technology does not involve the collection or use of information that could be used to uniquely identify an individual. But the regulators still found that TikTok was collecting and using biometric information, since its technology collected and analyzed numerical representations of various physiological features of individuals. And they found that biometric information does not have to be uniquely identifying to reveal sensitive information about an individual, such as their inferred gender. Therefore, the regulators found that TikTok should provide prominent, upfront information about its practices related to biometric information and facial analysis during its sign-up process, especially since the regulators took the view that this use of personal information would be outside the reasonable expectations of individuals, because users signing up for TikTok would have no reason to expect that TikTok would conduct an analysis of their facial features, nor would they be likely to review TikTok's lengthy privacy policy to learn about TikTok's biometric practices. In addition to TikTok, the two other big cases that I would highlight for Canada are the Clearview AI and Cadillac Fairview cases. So similarly to TikTok, in the joint investigation of Cadillac Fairview by the Privacy Commissioner of Canada and its three provincial counterparts, the regulators found that anonymous video analytics technology that was used in wayfinder kiosks in shopping malls to estimate age and gender of shoppers involved collection and use of biometric information. And since this would be outside the reasonable expectations of individuals who use these kiosks to find certain shops within the mall, express consent from shoppers was required. However, Cadillac Fairview was also subject to a class action lawsuit related to its use of this technology. And the Supreme Court of British Columbia refused to certify the class action because the plaintiffs had failed to establish that the defenders recorded the proposed class members' facial images and then created biometric or personal information from those images, since the technology only created numerical representations of faces, which could not be used to identify individuals or recreate images of faces. So this seems to be directly contrary to the position that was being taken by the privacy regulators, and we'll have to see whether this unsettled area of law in Canada progresses in the near future. Finally, because I know we're running quite low on time, I would direct our audience to the Clearview AI cases, plural, in Canada, because there was an initial joint investigation into Clearview AI, where this company collects images, scrapes them off of the internet in order to offer a service to law enforcement, which I mentioned earlier is a big topic here in Canada, so that law enforcement could identify suspects and witnesses in criminal investigations. And this was a situation where the regulators said that this technology was not permissible at all in Canada, and they recommended that Clearview cease offering its services in Canada and cease collecting and using images of Canadians, and also delete the information it had already collected. Clearview AI refused to accept this recommendation, and so it was ordered to comply in Alberta, BC, and Quebec, who have order-making powers. And Clearview AI challenged these orders in the courts. Both BC and Alberta have released their decisions. The courts have released their decisions, but they're somewhat conflicting, with the BC court upholding the findings of the regulators, whereas in Alberta, there was actually a finding that that parts of Alberta's Personal Information Protection Act were unconstitutional because they violated freedom of expression, since the exception to the consent requirements for publications was too narrow and didn't cover anything that was posted online. So again, this is an unsettled area and one where there's lots of developments, and I would definitely recommend that anyone who wants to use this type of technology to scrape images online and analyze biometrics should be aware of this line of cases. Unfortunately, I think we are out of time. I was hoping that we would have a few minutes for questions, but there was so much to cover that it doesn't look like we're going to have time for that. I apologize to the audience that we've run out of time, but I'll pass the floor back to Alessandra to introduce our next panel.
Thank you, Lindsay. Well,
thank you.
Thank you.
Thank you very much. Thank you very much, Lindsay. And thank you also, Isabel and Luiza, for this great panel. So we are going to move you all away. That was really fantastic, and looking forward to the next session. Now, we are moving from a general regulatory landscape to something more specific, which is law enforcement and government access. This time we are changing a bit, or most of the countries we are going to discuss about, because we are going to be focusing mainly on the US, Argentina, and Mexico. So in this second session, we will explore the critical legal frameworks and the privacy implication on government requests around this topic. I'm really pleased to introduce you also to the moderator of this session, which is Maria Julia Baumert. I hope I've been pronouncing the name correctly. Maria is correspondent at MLEX, which is a leading service for market insights and regulatory intelligence. So I'm really pleased to have her with us. And together with me and Maria, we will have three other speakers, which are respectively Mariano Peruzzotti, partner from the Argentinian law firm Allende Brea, which is, of course, our local member for the Privacy Rules Alliance, together with Mason Clutter from Frost Brown Todd in the US, and Alexis Cervantes, partner at Davar Abogados in Mexico. So 3 partners from 3 different jurisdictions with a journalist, a correspondent working on the topic for another great panel. Maria, I will leave the floor to you. I'd like to thank you all for this session, for being here, and looking forward to listening to you all.
Hello everyone, it's great to be here and to moderate such an incredible panel. I'm not going to steal time from any of you guys. So in a brief summary, I think Alessandro already explained it, but the plan is in this panel to explore how governments are dealing with the challenge of processing, dealing in analyzing biometric privacy. I would like to start with Mason and with the US. In the US so far, there's no comprehensive federal law governing biometric data, but it's still heavily used on airport control, immigration, and security related. Can you share a bit about the intersection of biometrics and government access, and are there any laws or rules that govern how law enforcement collects and uses this data, including through private companies?
Yes, of course. Thank you so much, Maria, and great to see you, Mariana and Alexis. I hope you can hear me. I'm having some tech issues today, so if I cut in and out, please excuse me. So yeah, I like this question. So I'll set the framework here if we have a framework. As you said, we do not have a comprehensive framework in the... So starting at the US state level and then working up to the federal level. From the state perspective, we obviously have 19 different state consumer privacy laws. These consider biometric data to be sensitive information. And so for most states, effectively means that they must obtain the consent of the individual to collect and use the biometric identifiers. We also have a framework of state-specific biometric laws that are directed at the private sector. Texas and Washington state. Many of these laws provide for a private right of action. So as you can imagine, they can be very costly for businesses if they do not comply appropriately. But the good thing about these laws is that they really do establish an easy to follow framework for the collection, use, retention, and destruction of biometric information. So the challenge knowing about them and then complying with them is called. And for both of these, whether state consumer privacy laws or the biometric specific laws, we're always allowing law enforcement access to this information pursuant to legal process in the United States. So that brings us to the quote federal framework, obviously with our U.S. Constitution. And in our U.S. Constitution, it's from the 1700s, but we do rely on the Fourth Amendment, which provides for a right against unreasonable searches, so the use of the biometric information, and seizures, which would be the collection of the information, and requires a probable cause standard, which is reasonable suspicion, to obtain what we call a warrant. So this would be a document that a judge signs off on that says you meet the constitutional standard to conduct a search or a seizure, and then that paper is delivered to the holder of the information, whether it's private sector business or the individual themselves, to then collect and search and use that information. Our law enforcement in the United States also, upon arrest, so again, meeting that constitutional standard, or arguably a general standard under the Fourth Amendment, collects biometrics upon arrest in this country. And we know that most familiarly with fingerprinting, right? And so that's been a part of our long history. And then finally, post 9/11 in the United States, there was a congressional commission that assessed the attacks and to verify identity, given entered and stayed in the United States. And so one of the ways, again, remember, this was in the early 2000s, so long before biometrics were really common, Congress suggested that the federal government consider the use of biometrics for identity verification or entry and exit under short-term stays or even immigration stays. And of course, in the United States, then the federal government and the national security ran with this. And so, as you mentioned, our most known and commonly public use of biometrics is for international travel to enter or exit the United States by non-US citizens. So if we use facial recognition as an example of the intersection of AI and biometrics, we know that this technology can be imperfect, and oftentimes it's inherently biased in a way that is not helpful to the particular use case. So without particular or appropriate safeguards in place to mitigate these potential, if somebody is solely relying on biometric matching in a law enforcement context, it has led to innocent individuals being targeted for investigation or even arrested in this country. And this obviously raises unique privacy, what we call civil rights and civil liberties, and even reputational issues for these individuals, which can be hard to recover from. So these are some of the issues that we are still dealing with as biometrics become more prominent in the United States. And I'll stop there because I think we're going to do a little bit of a deeper dive into the particular one department and how they may use biometrics later in the conversation.
Yeah, we'll definitely have a second question. So now let's turn to Alexis and to Mexico, where big changes are underway with the new national identity system. So the system combines fingerprints, iris scans, and photos to one identity platform. At the same time, we see Europe moving in the opposite direction, calling for strict necessity tests and even bans on certain biometric uses. Alexis, from your perspective, what would a minimum acceptable legal framework would look like to reconcile these big infrastructures with fundamental rights?
Hi, first, Maria, and yeah, you're right on, and I think that it's relevant to give this context that what's happening right now in Mexico in terms of the use of biometrics and how especially the government, how they're expanding its biometric and intelligence capabilities and at an unprecedented pace, I would say. And why is that? Because of the examples you provided. We are the Mexican government this last year has radically changed to curb on key what we call the Biometrics and digital identity. And one of the most serious topics that's been happening in Mexico is the design of a central intelligence platform, which is designated to enable graded interoperability across public services. And at the same time, this new legislations in terms of security, that of course it's understandable, but what we have to understand is that they're expanding all these analytic tools that are going to require, of course, the massive processing of Mexican citizens, and are going to require the processing of biometric data. And how the law is designed is to be these communications between government officials and government authorities with private sector companies. So this central intelligence platform, of course, we understand the purpose for which is created, but of course it raises a lot of concerns in terms of safeguards and data privacy. And on the other side is that our data protection landscape has changed radically. No, as all of you or most of you know, or if you don't know, Mexico. Previously in Mexico, we had an autonomous independent authority, that it's INAI, which safeguarded the data protection right, both for the processing of public entities and private entities. And because of the constitutional reforms that occurred in Mexico, that INAI disappeared, and the new authority of data protection is under the executive branch and under the Secretariat of Anti-Corruption and Good Governance. So as I mentioned, is from in one side we have these new laws that are going to require the massive processing of Mexican citizens' data, specifically biometrics. And the other side, we have a new data protection authority that is just a couple months into action, and that is going to have, of course, the main responsibility to safeguard the data protection right and to prevent any unauthorized uses of that data from Mexican authorities, especially, again, facial recognition technologies and the new identity technologies that are going to be used in a short period of time. So that's where we are right now. That's going to be the challenge, and we're going to have to see how this new authority reacts to this huge challenge that we're facing right now in terms of data protection.
Nice, perfect. And shifting to Mariano and Argentina, I believe we are in a close situation, Brazil and Argentina, where the biometric use of data is currently governed by the privacy data protection law. Luiza explained that earlier. So, Mariano, can you explain a bit how the current legal framework regulates the collection and use of biometric data by public authorities? And looking ahead, I see there is some major news coming also. What are the main legislative and the regulatory reforms expected in the next 2 years regarding the biometrics?
Sure. Thank you very much. Thank you for having me here. It's a pleasure to join this panel with Mason, Alexis, and Maria. And thank you to all of you for joining this session. Well, yeah, as you point out, the collection and the use of biometric data by public authorities is mainly governed by the general data protection principles and rules, as well as the relevant regulation issued by the local authorities. In Argentina, we have the Argentine Personal Data Protection Law, which does not include any specific reference to biometric data. And the reason behind this is very simple. The law was enacted in the year 2000, and it was not subject to important adjustment or reforms. So that's the main reason or the main ground why you will not see any reference in the Argentine data protection law concerning biometric data. Even considering that the Argentine law was inspired on the European data protection regulations. Besides this, Argentina joined Convention 108 and Convention 108 Plus of the Council of Europe. And as you probably may know, this convention specifically addressed the processing of biometric data. Having in mind this, the Argentine Data Protection Authority issued Regulation 4 of 2019, which approved a set of guidelines on the application of the Argentine Data Protection Law. These guidelines include a specific section on biometric. And this section states that biometric data will be deemed sensitive data only when it may reveal additional information whose use could potentially result in discriminatory treatment of the data subject. For instance, data revealing ethnic background or health-related information. As you probably may know, sensitive data, according to the Argentine Data Protection Law, and it's similar to different regulations around the world, is subject to a more stringent regime. For instance, in Argentina, if the authorities, the public authorities, will collect and process sensitive data, they have to obtain the consent of each data subject or has a legal authorization for this processing. This is the current situation nowadays. As some years ago, in year 2022, a bill aimed at amending the data protection law was introduced in Congress. This bill considered the biometric data as sensitive data, but unfortunately, this bill had never been discussed in Congress and finally lapsed in year 2024. But the DPA has recently voiced that they will resume negotiations and discussions to reintroduce an amended version of the data protection bill next year. In fact, last week we have participated in the first round of discussions with the Argentine Data Protection Authority in the sense of resuming this kind of discussions.
That's very, very interesting. Going back to the US and to Mason, Mason was Chief Privacy Officer at the Department of Homeland Security. Homeland Security is a key agent in the United States framework. So, can you speak to the ways in which the department and its many law enforcement agencies use biometric information and using facial recognition as an example? Where do you think are the safeguards that we need at play at the moment? And are there any challenges in your experience there at the Homeland Department? How did you address them?
Thanks, Maria. So I'm really glad we're having this conversation today, because I think as privacy experts, we certainly appreciate that biometrics are incredibly sensitive information, right? These are immutable traits that somebody cannot change. So not only can they be incredibly helpful and beneficial for, private sector businesses. I know we heard Lindsay speak in the previous panel about the ways in which companies are using biometrics to facilitate security and time card keeping, et cetera. We also have to balance that with the potential risks to the individual, because you can't change your face, you can't change your fingerprint, you can't change your DNA, right? And so when you think about private sector use is very risky, especially from a security perspective, but all of that biometric data that is being collected in the private sector, as I mentioned earlier, is subject to potentially law enforcement access, which is where the intersection of rights and freedom and even life in this country can come into play. So I want to be clear that when I was at the Department of Homeland Security, I left in August of 2024, so I can speak to my experience then. But as I mentioned previously, and as you said, Maria, most visibly, use by the Transportation Security Agency for our domestic security at the airports, and use by Customs and Border Protection to facilitate international entry and exit, also to verify identity. Again, these are considerations from the 9/11 Commission, are what people see most visibly in the United States. So I'll say one of my claim to fame, if you come to the United States, you will see at the TSA checkpoints a big stop sign that says, stop, you don't have to go through this process and you won't lose your place in line. From a domestic perspective, there's an opt-out right for everyone. When we're talking about CBP and international travel, unfortunately, there is not an opt-out right for non-US citizens, but there is in this country for US citizens. The department also used biometrics for voluntary programs. So in the United States, we have international travel programs domestically called Global Entry. This helps individuals go through customs and their return from international travel seamlessly and more easily without having to wait in lines. It uses your biometrics to, again, verify your identity. Same thing for what we call the pre-check process through our domestic security apparatus. But I will highlight that these biometrics that are collected for these voluntary programs go into the same database, but they are supposed to have different guardrails around their use. Now, guardrails, again, as we established, are policy-based. In the United States, we do not have a comprehensive law with respect to law enforcement and the use of biometrics, notwithstanding the Constitution. And so your guardrails really are only as foolproof as the individuals who are implementing them. The department also used biometrics to facilitate provision of immigration benefits. So again, in this context, to verify identification and ensure that benefits were being assigned to the correct individual. Now, recently, I saw a notice of proposed rulemaking from the Department of Homeland Security, specifically the USCIS, Customs and Immigration Services, to begin collecting from everyone biometrics, including potentially DNA for familial verification. And so again, when we're talking about potential risk, we can certainly see the benefit in the context of immigration to verify that an individual is a member of a particular family. But there are risks there with respect to, of course, secondary uses. And again, DNA reveals a lot more than just familial verification or familial ties. So how is that going to be regulated? What are the safeguards against that to ensure that we're not using DNA for purposes of perhaps identifying, as Mariano was indicating, health-related information or other information that could could factor into an individual being able to receive immigration benefits. We also engaged in international collection and sharing. This was to safeguard our own borders and to learn about potential disqualifying criminal activity for entry or even benefits. So one thing I want to highlight, though, if you're interested, especially on the international front, because we're talking with an international group today, is that we issued privacy impact assessments. You know, one of my primary roles as the Chief Privacy Officer was to assess and mitigate potential privacy risks of unique technologies, programs, activities, anything that the department was doing that could impact privacy. And so these privacy impact assessments are available online. They may be in, quote, archived content at this point in time, but nonetheless, they still exist. So you can take a look at the ways in which the programs are used and the mitigation measures that were put in place to safeguard privacy. I know you asked about facial recognition, so I'll jump into that quickly. You know, facial recognition, again, is an easy example of the intersection of biometrics and the use of artificial intelligence. And so I'm glad that you brought this up, because it really is one of the things that I mentioned before I'm most proud of from my tenure. And at the time, again, this is available in archived content on the web, but we developed and implemented at the department the U.S. federal government's first facial recognition and facial capture policy. And in part, that policy required that all uses of these technologies be thoroughly tested to ensure that there's no unintended bias or disparate impact, right, in accordance with national standards. And so I was a very big pusher of this being independent testing, right? We can't have an agency doing its own testing and then essentially say, trust us, it's all fine. So this was to ensure that independent testing occurred of agencies, both the use of their particular algorithms and the particular use cases. As I mentioned as well, U.S. citizens are afforded the right to opt out of face recognition for non-law enforcement uses. And what's really critical is that the policy provided that facial recognition or facial capture technologies and matching cannot be used as the sole basis of any criminal or civil enforcement related action. So again, to my international colleagues, I'm sorry, but for U.S. citizens, this is particularly important, but for everyone, it's important that there was a human in the loop, right? Corroboration of the output was required to be able to use the output for any enforcement purposes. And then finally, we really approached a privacy and security by design framework where we ensured that the department's oversight offices, including the Privacy Office, the Office for Civil Rights and Civil Liberties, and the Office of the Chief Information Officer, reviewed all new and existing use cases. And so this, again, is a privacy by design framework. And I know we hear this as privacy professionals all the time, but how important it is to have the right people at the table when you are developing a new tool, technology, system, program, whether in the private sector or in a government setting. So we also took a look back. We assessed the current uses of the technology at the time to assess their compliance with the new policy, and we adjusted those uses accordingly. And we even issued a public report on our findings. So transparency is also key here and something that was built into our framework of safeguarding privacy in the context of the use of facial recognition. So the last thing I'll flag is a particular kind of technological nuance, but this is something we see when it comes to facial recognition, no matter where it's used. And depending on where the threshold for a match is set within the algorithm, this can set the baseline for either enhanced security, which has greater implications, of course, for privacy, or lower security, which has heightened safeguards for privacy. So where the threshold is set really does affect the policies that should be in place to mitigate potential risks. So for instance, if a threshold is set to provide a match of, let's say, within 98% certainty, then many people may ultimately be determined to not be a match, even though they are who they say they are. And this can lead, for instance, in an airport circumstance, for an individual to being delayed or missing their flight or even detained. Again, even though they are, in fact, who they say they are. So you have to build in mechanisms to address this reality. For instance, to include simply reverting back to original authentication measures of visually reviewing and authenticating an identity document, not just, again, solely relying on the output. And of course, again, the lower threshold for a match, the more likely that individuals who are perhaps faking their identity can get through. So you can probably guess where the threshold was set at the department for this particular use case. And again, the safeguards we put in place were very much informed by the risks that the threshold setting could realize. So I'll turn it back over to you, Maria, but happy to take any questions on this.
Nice. I think we will move over to Mexico now, and with Alexis, I'll be quick. With the new national ID becoming mandatory, and you spoke before about the new Data Protection Authority and how that's still a complicated issue in Mexico. What do you think are concrete safeguards that should be non-negotiable?
Well, first of all, we have to remember we do have even with the change of the authority, we do have comprehensive laws, and we do have laws that are very similar to GDPR, and we do have laws that have these core principles of strict necessity, proportionality, security safeguards. So what we have to look at is we especially as privacy lawyers or wherever we are that could impact and this concern we have of the processing of this data is that we should demand. One of the key things for me is we should demand transparency, right? We should demand transparency from the government in terms, and Mason I think was very clear on that, on the impact assessments. Has the government taking this impact assessment? Can they prove that this collection of biometric data is necessary, or are there any other ways to be less intrusive to achieve the goal? This is what we as privacy lawyers always ask ourselves. Do we really need this data? This data is sensitive. Can we achieve the same goal with the use of this data without processing this much data? That's the first thing, right? Second, we have to have rules. They have to have rules. When can we access that data? On what scenarios, right? And that has to be transparent, because we all as privacy lawyers know that when we go to a company and there's a database and there's a rich database and there's a lot of potential in that data, like could be in biometrics, it is very tempting to misuse the data. It's very tempting to repurpose the data. So one of the key concerns and one of the things that have to be in place are these measures for the government to avoid any misuse or any repurposing of the data, because that's normally when the big risks materializes of that misuse of data. That's the first thing we want to avoid. We want to make sure that the data is only used for these security purposes. And of course, it's understandable in the state we have in Mexico and the security issues we have, and that we need technology to fight against crime and to fight against drug cartels and to fight against all the things, the problems we have. But we have to know that we have to balance it with the data protection right, that it's one of the rights that gets the most impact in regards with these technologies. And second, and the second thing is that we cannot forget cybersecurity. When governments usually build these central platforms of intelligence, is what cybersecurity experts usually call they create a massive honeypot, right? This is so attractive to criminals. These databases are what criminals and hackers are always looking for. So our government has to understand this and be smart about it and take all these security measures that are necessary to protect the data. Because if this data is misused, the negative impact it could have on Mexican citizens, and we're one step closer to becoming a mass surveillance state if we don't take care, if we don't see the problem that could happen if this data is misused. So we're at a critical stage I think our new data protection authority has a great opportunity to lead the way, to lead as an example on how biometric data should be used when it's in government possession, and that should translate to private entities also, because it's not only the government. We could have all these misuses in terms of HR in companies. So it's we're going to see what happens, but it's a key moment for Mexico and the use of biometrics.
Nice, perfect. And Leslie, Argentina, and Mariano, we can start to get a bit more specific here. We have seen a lot of important precedents on government access to biometric and other sensitive data. Buenos Aires itself has been recently at the center of the debate. Mariano, what lessons can be drawn from the decisions, and how do they shape the limits and expectations for law enforcement access to that biometric databases?
Sure, yeah, you mentioned a very important case. A few years ago, the city of Buenos Aires implemented a facial recognition system for identifying fugitives. This system relied on a live video feeds installed in the subways and public areas and cross-checked those faces against a national registry of individuals with outstanding warrants. However, soon after the implementation of this new tool, an NGO called ODIA, in Spanish it means Argentine IT Law Observatory, filed a constitutional action, which is called in Argentina Amparo, challenging the system. It is a very brief proceeding. The claim was not about opposing the use of a specific technology per se, but about the absence of privacy safeguards that a biometric system, as this one, requires before going live. Odia argued that the system enabled mass capture of biometric identifiers from anyone walking through public spaces, particularly in subways, without prior notice, transparency, or adequate legal basis, something that was mentioned by Alexis just before. Odia highlighted as well the risk of false positive, because there was some cases of two or three cases of false positives, the potential for discriminatory bias, and the fact that biometric templates could hypothetically be retained or reused in ways incompatible with purpose limitation, which is an important principle according to the Argentine data protection law. And what was very crucial, or what was very important in the debate of this case, the government had not conducted a privacy impact assessment. Before entering on this debate, it is important to highlight that according to Argentine law, there is no mandatory data privacy impact assessment. It's just a recommendation of the Argentine authority, but it's not mandatory. The first instance judge dismissed the case, but on appeal, the Court of Appeal reached a very different conclusion. The Court of Appeal recognized that privacy, non-discrimination, and data protection rights were clearly at stake here, and that individuals could be harmed simply by being exposed to real-time biometric identification without safeguards. The Court of Appeal stressed, particularly in this case, that this was not a theoretical concern. Any person recorded by a camera could be subject to automatic processing capable of altering or affecting rights, individual rights, particularly considering that in Argentina, data protection is a fundamental right. And especially considering as well, because the system revealed that there was kind of false positives. Because of all these risks, the court decided to suspend the operation of this system until robust measures were implemented. And which means this? Well, first of all, the city of Buenos Aires must implement a data protection impact assessment. Secondly, an independent oversight mechanism is required. Third, as safeguards against discriminatory outcomes should also be implemented in the case. And also the authorities must deploy controls over data retention, access, and auditability. To wrap up, the case is very important for us because it reinforced, in a sense, three principles that are very relevant in Argentina. The first one is that public sector the use of biometrics by public sector must meet the privacy standards. All the principles and the provisions that were mentioned by Alexis and Mason: transparency, data privacy impact assessment, minimization, proportionality. All this must be considered when implementing or deploying this kind of tools, which, as mentioned by Alexis, they are very important and they could reveal some kind of problems to human rights and so on and so forth. The second one, that an impact assessment is necessary in those cases. And the third one is that the courts are willing to intervene in those cases in which human or fundamental rights are in danger. So basically, that was one of the most important cases here in Argentina so far.
Thank you very much, and thank you very much for everyone. I think it's been really, really interesting to hear. And I think I'll get back to Alessandro.
Am I in? Yes.
Yes.
So, thanks. Thanks a lot, Maria, Mariano, Alexis, and Mason. That was really a hype opening session on a very, very relevant topic. So thanks a lot for being with us. I would like to close this session while warming up our audience for the next one, which is going to be on a very different topic. Basically, we are going to shift from a session that were more generic, giving us more of an overview, to something that will be giving us more practical type of advice. Next session will be on sectoral impacts, but before starting, we will just take 1 minute break with a short video from privacy rules, and then we will reconnect with you all after a few seconds. So let's pass to that and then joining the next session again. Thank you for your presence and for following us.
Managing global privacy compliance feels overwhelming? Expanding into new markets is exciting, but navigating dozens of privacy laws is not. The rules change, expectations rise, and compliance becomes a constant moving target. How confident are you in your global privacy readiness today? Privacy Rules is the world's only global alliance integrating legal, tech, and crisis communication experts under one coordinated umbrella, delivering unified privacy solutions across more than 55 jurisdictions. We simplify global compliance, mitigate cyber risks, and protect your company's reputation with scalable, 24/7 expert support across borders. From multi-jurisdictional data breaches to international data transfers, privacy policies, market expansion, and M&A due diligence, we provide tailored, cost-effective privacy solutions for your global operations. With simplified contracts, centralized case management, transparent processes, and dedicated global support. Our alliance gives you confidence and clarity wherever you operate. Simplify global compliance. Protect your organization with the world's leading integrated privacy alliance. Contact Privacy Rules today.
Perfect. And here we are again. So I'm now pleased to introduce you to the next session, where we will discuss about the practical application of biometrics in various industries. We will have a specific side on fintech, but of course there is much more to discuss. Moderator of this session is going to be Gene Price from our US member firm Frost Brown Todd, where he is one of the partners. Hello, Gene, nice to see you. That will be joined by some of our speakers. One is a distinguished guest, which is Javier Buitrago from the Panama FinTech Association, where he is the co-founder, together with two other privacy rules experts, which are Mariela de la Guardia from ICASA Law in Panama and Thomas Pintor from BitLaw in Chile, both partner of their respective firm, to conclude a panel of very high-level experts on the topic. So without further delay, Gene, I leave the floor to you. Thank you all for being us, and thanks to our listeners for being here also for this session.
Okay. Thank you, Alessandro. So good to have everyone here today. We hope this is going to be really interesting and informative for you. We have three outstanding panelists here. I'm going to let them introduce themselves here in just a moment. But we're going to be talking about authentication, primarily in the context of identity. And as we were discussing yesterday, Tomas was reminding us that there's really three different ways that you can do identification. Knowledge, something like a password, possession, something like a token, or it could be the PKI relationship or process, and then inherent. And that is what we are. And that's where we're going to be talking today. It really is probably the future of biometric identification as that process to become the leader globally. I think all of us are familiar with Apple's app, where I just look at my phone and all of a sudden it just turns on. That's a biometric application. So we're going to be getting into how these things work, and specifically what the laws in the Americas say about biometric identification and authentication. So to begin, I'm going to ask each one of our esteemed panelists if they would speak just a little bit about themselves and also about their background. So Mariela, let's start with you.
Hi everybody. My name is Mariela de la Guardia Oteiza. I am partner at ICASA González Ruiz Alemán in Panama. I have a background in corporate law and IP, and now for all this new legislation on data protection. That's me, and I don't know if you want me to give a background on Panama's framework, or we leave that for later.
Yeah, go ahead and give that now, Mariela, just a short background.
So, just short, our data protection law is contained in the Law 81 of 2019. That was a little bit a year after the GDPR was enacted. And Panama followed the GDPR principles and rights. And that's it's a general law. We have certain special laws for banking, insurance, and trust, for example, and also for the patient's rights. However, biometrics is contained in our executive decree, and our law establishes sensitive data, biometrics inside sensitive data. And for sensitive data is required informed consent and a purpose consent, right? Our decree on biometric establishes the following. Is personal data obtained from specific technical processing related to the physical, physiological, and or behavioral characteristics of a natural person, which allow or confirm the unique identification of said person. We have a provision in our decree, and we have a provision on sensitive data. So this is the framework that allows us to provide our clients or the subjects in data subjects in Panama, their the specifics on their biometric data. I don't know, Javier or Tomas.
Yeah, Tomas, if you would give us the same thing that Mariela just went into.
Yeah, first of all, thank you very much for Privacy Rules for the invitation. My name is Tomas Pintor. I'm a partner at Bidlo. I'm in charge of the fintech and financial services regulation of the firm. My background is mainly related to financial regulation. In my previous role, I worked for the government, specifically for the Ministry of Finance. I was in charge of drafting and making the negotiations with the National Congress of every bill that has to something to do with the financial system, right? One of them was the fintech and open finance law that took me a while. So since then, I've been pretty much related full time to this topics, right? When it comes to the Chilean situation, it's kind of I think that is very developed in comparison with other countries of the region, but for very sad reasons, right? That is fraud. Basically, we have a very bad fraud legal framework that establishes a very high bar for the proof in courts. So that basically makes that banks and issuers of cards, payment cards, must respond up front for any fraud, and that obviously made that some people start taking advantage of this very bad design framework and start making self fraud. So we have one where champions of the world in terms of frauds is not a good metric, that one, right? So that's the reason why we have an amendment recently in our country of this framework, and that try to correct this bad design law. And it established that if you have, as you were saying, Jean, if you had two of these three components of a authentication process, that are knowledge, possession, or inherence, you could have some chance of not responding against the fraud, right? Because it is interpreted as a strength two factors authentication process. If you meet two of these criteria, two of the three criteria, right? So obviously, and as you were saying, some of the most popular devices as well bring this type of authentication. Many of the financial services providers are making their authentication processes with biometrics. But yeah, now we're in discussion if is it if the authentication process it is provided by the device and not by the company, the financial company or the financial provider themselves. Does it count as a second factor and then as a this strength two-factor authentication process? Yeah, but mainly that's the situation in Chile. That's the reason why we have had a lot of discussion around these topics.
Moving forward ahead of the many other countries, it's good to see a framework that other people can emulate and maybe make better. So let's go to Javier. Unique in our panel, he's not an attorney, but yet he has extensive experience all the way across South America. Javier, why don't you tell us a little bit about yourself? You're muted. No, not yet. Alessandro, could you unmute Javier, please? Okay, you're unmuted now. No. I'll tell you what, we'll come back to you because I think there's an issue on your end. Let's go to the first question, which I'm going to ask Mariella to take, but then I'd like for Tomas to follow up because we was on this. Generally, how are governments in the Americas approaching the adoption of biometric technologies from a regulatory perspective? And are there any real world examples that demonstrate the impact of those technologies on fintech companies? Now, I'll say this, and good to have you back, Javier. In the United States, we don't really have regulation on any of this. We have several states that have moved out, like Illinois, Florida, and a few others, California, regulating some things. But the Biometric Information Privacy Act, which is unique to Illinois, is the only one that's really robust. So that's just one state out of 50. So there's not a whole lot going on in the United States regarding biometric regulation per se. Mariella, how is it going in Panama?
Well, in Panama, we don't have a fintech law properly done. We have open finance. And financial institutions use the general data protection law on biometrics. They have to follow the consent for biometrically sensitive data and follow the law, the general law on how they process this data. And not only for fintech, in general matters, and something that I have to mention that is very important to be to take into account. The data subject's own image, their face, is a right considered in the Family Code of Panama. Everyone is entitled to their own right, and they need to provide a consent on the use of their image. For this purpose, for example, the ID or the passport of a person requires their consent. If you enter to a public or private building, you need consent from the person to capture or scan that ID. Our national protection or direction of data protection issued a note to all the buildings and places, private and public, that they cannot scan or take a picture of the ID or passports. That was prohibited, and this raised a lot of concern because certain communities that are considered a target or security, or for security matters, they raise their little, hey, we need the security to scan the image of the persons entering to these buildings for security matters. So this note has been created like a lot of noise because we have two lines, security, and the other one is their own biometric data and the issues on processing this information and who gets this information. So there has been some issues around this note. But once the company or the building in this case, or the bank on biometrics, when the face is scanned to enter the bank account, is required consent. You have consent, you have your safeguard, you are in compliance.
Okay.
I don't know.
Thank you, Mariella. Tomas, could you just follow up on that?
Yeah, I think that I can talk about what governments have been doing in the region when it comes to open finance systems, right? That is, when you talk about authentication, is one of the most important things in a system that is defined as one that lives for the exchange of data, right? Financial data, and in which in many cases, for example, or at least in Chile, the privacy regulation is not the first one that in rule, right? We have a general application of the privacy regulation when it comes to the open finance system, in which we have the principles specifics rules, right? In which the financial regulation is the one that is in charge of setting the regulation for the exchanging of financial data in an open finance system, right? Because it is related to another different topics such as technical standards and other things, cybersecurity. But yeah, so the authentication is one of the most essential things in an open finance system, and I've seen that another thing that an open finance system can do besides the exchange of data is payments. And when we talk to people that provides payment services, they are very, very worried of the UX experience. And if you have a very friction process of authentication, it can put everything down, or all the effort or big part of the efforts are pointing to have the best UX experience. So I have seen in Brazil is the one in the region that is most ahead of everyone, and they have two types of authentication, right? You have the one that is redirected to the environment of the issuer. So you have one fintech service provider that is in charge of getting the consent of the user, and then for the authentication, you have a redirection to the environment of the bank or the card issuer, right? And the authentication, you do it there, and then you do the whole rest of the process, and you get the information. That is not the best scenario for a fintech service provider, for a payment service provider, because it's friction, right? Mm-hmm. You have a redirection to the bank environment. So in Brazil, what they did is the payment without redirection, or jornada sin redireccionamiento. That is, you trust in the authentication that the fintech provider does of the user. So I think that we have the example of payment services providers, payment initiation services providers in Brazil that are doing this with a lot of volume, and they're with a lot of strength, and they are making it's a revolution in the payment industry, right? Mm-hmm. So I think that's where the governments are trying to study and try to get ahead of the problems that such practice could bring, right?
Mm-hmm. Okay. Yeah, I agree. And I have several questions I'd like to follow up with, but we have Javier back. And Javier, we already have several questions coming in from our audience, and we only have 20 minutes left. So let's get into some of those. And I'm going to ask you the question, but I would like for you to preface the question with just some background on you, and then answer the question. Okay? Perfect. So here it is. What are the biggest operational challenges for fintech companies who are adopting biometric verification in onboarding or fraud prevention?
Well, again, thanks, Gene, for this space. I'm a fintech business guy, and I have been working in the fintech industry for at least more since the beginning, and before that in payments and lending. So I have been around a little bit all over Latin America. I'm Argentinian, but enjoying and living in Panama with Mariela. So I have seen the fintech revolution in Argentina, and enjoyed being part of that. And I'm also enjoying and being part of the fintech revolution here in Panama. And what Thomas just said is a key factor. I mean, when we talk about fintechs and opportunities, friction is a killer. When you say why people use fintechs, 40% of the fintechs are being used because you have a 1 minute onboarding and you're already inside the solution, the app, and already doing payments. So again, velocity is key. And of course, fintech is all about using the best technologies that there are in the market to simplify the way that people moves around their financial solutions. So this is key. Velocity is key. Friction is a big problem, and biometrics is fantastic. And when we talk about biometrics, keep in mind that you have people paying with the fingerprint. You have people paying with your palm. You have people paying in Asia with Alipay, with the program Smile to Pay. And you have people validating with the iris. You have people validating with the face, with the voice. So when we talk about biometrics, this amplifies a lot of these solutions that provide solutions to different scenarios and helping everyone, because this technology, the fantastic, is democratizing everything. Keep in mind that even the poorest in Latin America is using this technology just because they can access a smartphone. So this is not for the richest guys in the country. As Tomás is saying, we are seeing this in Brazil everywhere, all the segments in the population. And this is fantastic because it involves the whole community. I used to work in Falabella, Chilean retail, fantastic retail, and we used to deploy fingerprint validation on the Falabella financial solution on 2007. So we have been working this market for a long time. Alipay launched this Smile to Pay program on 2017. So again, this is when people ask this kind of question, I always say, again, keep in mind that we are late to the party, so we have all the information from everywhere in the world to see how they have solved. India has done a fantastic role with the program Aadhaar, and with that program, they validate everyone and open the biometric financial validation for everyone in the market. Argentina also in 2017-18 with RENAPER opened the validation. And again, the factor here, the key thing here is simplify our community lives and involve everyone. Keep in mind that in Latin America in general, half of the population, more than 300 million population, they are not involved in the financial system because they are using cash, they are using checks, they are taking the money off the account and paying every day in bills. Even in Panama, we have a lot of financial inclusion to do. So again, biometrics is I think is fantastic, and we have to focus on adding value to our friends, to our community, to solve people's lives, and then all the rest. We are professionals. We can manage and we can see which is the best solution, which is the best balance, as Thomas was pointing out before. We have been doing this for so many years. There is so many things to learn, and again, keep in mind that as a business guy, I will tell you, technology is changing every day, and when technology changes, our user expectations change, and when our user expectations change, we as a business guy think of new solutions to solve those problems. And this is a challenge for regulation. So we need to work, public sector and private sector, to take the best advantage of the new technologies to solve people's lives. And I'm blessed to be here in the panel with you guys. Thanks.
Okay, thank you, Javier. We're getting more questions, and I'm going to go to those questions because they're very practical, and this is for everyone out here. So this next question is, do you see biometric age verification systems becoming a regulatory requirement in certain industries? And if so, which ones? I'll throw that out for everyone. And you guys, in the 11 minutes we have left, see how you can do with it. Go. Who'd like to take it?
I think I'm going to start with that
Tomas,
one. Yeah, it's a very good question, right? Because and it specifically touches in here in Chile because of this regulation that have just been issued related to authentication, and it is a question that the regulator made to himself. Is it the biometric authentication regulation that we could set up as a requirement? And the answer is no. Why? Because of the cost that is related to establish as the bottom requirement biometric authentication. And but the thing is that you can establish incentives to maybe if you had that standard of authentication, you're going to be able, for example, in the terms of fraud, to be able to not respond upfront when someone is making, for example, a self fraud. So you can place those incentives. The answer, finally, I think, if the financial system that is, I think, basically one of the most critical when it comes to authentication, because your money is involved in it, is not making the choice of establishing as a bottom requirement the biometric authentication. I don't see it as at least in the short term, as a requirement that any industry should or could adopt as a basic requirement. I think it's going to be at the disposal of the industry, maybe for UX experience or for the design of products, or maybe for a provider that wants to show that it has the best standards in terms of security. But I don't see it as a basic requirement.
Okay. And Gene, on my side, I will say, what are you trying to solve? So let's focus on what are you solving, and after that we see what is best for that. And keep in mind that technology is helping us change who controls what. We have been using credit cards for the last 70 years or more, and at that time the control of the cards were in the bank's hands. And now with fintech solutions, you can say, okay, I want the card, but I don't want that card to be able to pay online, or I don't want to be that card to be letting ATM machines work with that card. So the technology help us start bringing the control of the payments and the solutions to the customer. So again, what is the problem that you want to solve? And after that, we can think which is the best technology, which is the best solution to answer your need.
Yeah, I think that's right. I know in the United States, there are several states that have already enacted age verification laws, primarily to keep people who are younger from visiting pornographic websites. But there's already litigation on it saying, well, you can't do age verification that way. And it's you have to know what you're trying to accomplish. You're right. Let me get into go ahead.
I will say the problem is totally different here in Latin America. The problem here in Latin America is kids they don't have any financial solution. All kids in Latin America, they are learning financial with cash, because in general, most kids don't access financial solutions. In fact, I was talking with the regulator a few days back about Argentina is letting kids start investing in Tesla or Apple stock or whatever, because if not, they will go to crypto. That's the only option they have. So again, we need to start including everyone. This is about financial inclusion and opening doors. Thank you, Gene.
Okay, thank you. So we've had two good questions, and here's another one. And I'm throwing this one out to all three of you again. How can organizations balance protection of individual civil liberties with complying with the legal frameworks themselves that are rapidly shifting? And I think every one of us can appreciate where the question is coming from. As soon as you try to comply, some judge will say, well, that law can't work that way. So experts, what do you think? How do you cope with balancing civil liberties and legal compliance?
Let me give an example with Mariela. Mariela, we can talk about the FinHub. So for instance, in Panama, we have launched the FinHub. Mariela, please help me there.
Can't hear you.
No, are you on mute, Mariela? Well,
exactly. Yeah. Sorry, I was muted.
There you go. Please.
Yeah. Let's say if there is a legitimate interest, if there is an exception from the law, for example, if it's coming from the exceptions, for example, if it's from public domain or accessible public media, or in the exercise of a public administration, or for financial, banking, or commercial interest, if there's a commercial relationship or a legitimate interest, as I mentioned, you can access that information, that data. Now, on biometric, of course, sensitive matter, sensitive data, but if you can prove that you access the information, the data, on one of the exceptions, you are covered, you are in compliance, you will have your safeguard, right? And in the case of fintech and what we just mentioned on age verification, that I wanted to point out something here is, in Panama, you require the consent of the parent or the guardian to act for the kids or underage person to access this information. Nowadays, I see many of my friends' kids, they have their phone and they have their access to their bank account, and they can receive, we call it the Yapi here in Panama, and they, with their face, they can do it, and they can pay, and they can access it. So that's something that comes to my mind right now on fintech. Age verification in some other sectors, for example, and it's not only in Panama, you've seen it in other places. When you access a web page or any commerce on alcoholic beverage, you need age verification. I mean, they won't say, okay, this kid is actually 16. They just put any. There's not a real verification. So that's something that, like, food for thought. Yeah.
Okay, Tomas, you have any thoughts? We haven't heard from you for a few moments.
Yeah, I think that it comes to, I'm gonna sound like I repeated this, but I think that the public sector has to bear in mind that they have to establish incentives to the financial service providers to adopt this type of verification processes. But you cannot. It is a very good question. Is it another way of seeing it? Does it you're violating civil rights when you establish it as a basic requirement? I think maybe it does. So the point is to design regulatory frameworks that incentives this type of processes, and is what Javier was saying, right? That the technology is at the disposal of everyone, and you have to use it in terms of security and for the design of best products and for financial inclusion, right? That is what it comes to mind with that question to me.
And let me add to that a lot of solutions are opt-in. So you are giving the solution for the customer, and if the customer wants, he can use it, and if he doesn't want, he cannot use it. And that's on one side. And on the other side, in Panama with the BID, the IDB, we launched here the FinHub, and this FinHub is a web where any company, any citizen can ask all the regulators at the same time, all the regulators, about any solution. I want to implement this. How you see it? What regulation will apply? What's the recommendation here? So again, we need to continue looking for ways to advance faster. The name of the game is implementing fast, from my point of view.
Okay, I think we only have we're less than a minute away from our time. I think we needed a full hour and a half to really get down into some of these questions. I really appreciated the intellectual rigor that went into writing those questions, and also from our experts, some of the ideas, the thoughts that you put back. So with that, thanks to all of you, the panelists, and thanks to everyone that's listening in. Privacy Rules is a terrific organization, a global alliance that will help you no matter where you go on the globe with your privacy, cybersecurity, and data protection needs. So anything from our panelists before Alessandro comes in and cuts us off?
Take advantage of biometrics and all new technology to improve people's life. It's all about implementing and solving problems. So thanks, everyone.
Thank you. Thank you, Privacy Rules, for the invitation.
Thank you, everyone. Thank you.
Thank you. Thank you. It's been a great session. Thanks a lot for those critical insights. It was very practical. Thanks to the audience for joining with some questions that have made the panel even more active. We move from now from one practical session to another practical session, because we are going to speak about risk management and best practices. And we are going to do so with another panel of very high-level experts from several and different countries from the Americas. Luckily for us, our moderator is Cecilia Bente, partner at Bente Stewart Abogados in Paraguay, that is now joining us. How, Cecilia? Together with another guest speaker, which is Isaac Morales, Managing Director and of Cybersecurity and Privacy Communications for Latin America at FTI Consulting, together with the two more members of the Privacy Rules Alliance, which are Paulina Silva, partner at BitLaw in Chile and colleague of the partner we had in the call before, it was Tomas, and Juan Manuel Pitaluga, partner at Pitaluga Abogados in Uruguay. So another great panel, a lot of experts from different countries and from different sectors for our audience. Ceci, I leave the floor to you, and thank you all again for being with us and also for this session.
Perfect. Thank you, Alessandro. Good afternoon and welcome to the last session. Thank you for staying here until the end. Now we are going to talk about risk management and best practices for biometric data. Before we begin, let me briefly explain the format of this session. I will be moderating the discussion and will also share some insights from my jurisdiction. And then we will move into a conversation with our speakers, and we will all be answering some questions regarding this subject. So first of all, I would like to start with a general landscape of biometric regulation in each jurisdiction. So I leave the floor to Paulina.
Thanks so much, Cecilia, and thanks, Privacy Rules, for this invitation. Well, Chile. We're going to talk a little bit about Chile. The main framework governing the processing of biometric data is in our new data protection law. And I say new data protection law because it is actually not even unforeseeable yet. It'll become unforeseeable on the 1st of December next year, after a very long time of discussion before Congress. This law was being discussed for 7 years. And it was published last year, and it regulates, as foreseeable, it regulates biometric identification for the first time. This represents a significant shift. We did have an older law that is currently unforeseeable, did not expressly regulate in any form biometric data, only lightly it would regulate sensitive data. This new law directly addresses this issue and incorporates for the first time both a definition and a specific regulatory regime, which resembles GDPR very much, as also expected. So under our new data protection law, biometric data is first classified as a type of sensitive data. When the law defines sensitive data, mainly through examples, it includes biometric data, but then it defines it and it refers to data being obtained first from a specific technical processing, and it must relate to physical, physiological, or behavioral characteristics of a person, and it must allow for a unique identification of that person, and then it gives out examples like fingerprint, iris, hand features, facial features, voice. The law is very explicit regarding the general rule for processing biometric data, which, no surprise there, it's express consent from the data subject. And it also adds on top of it a specific information requirement where the data controller must clearly disclose and this will, of course, usually live in the privacy policy, the specific biometric system that it's used, the purpose, the period for which the data will be used, and how the individuals may exercise the right. These are very narrow. They relate to life or physical integrity when it's at stake, public health alerts, certain very specific scenarios of scientific research carried out in the public interest. But always the underlying principle is the same. If there's a less intrusive way to achieve the intended purpose, biometric data should not be used generally, and if it is, it should be associated with a PIA. At the end of the day, the legislator's message is if you're going to use biometrics, demonstrate why is it necessary, how you will protect the data, which safeguards are you using. And then for organizations, this translates, of course, into a higher standard of governance, which is and security and risk assessment, which is completely new to the Chilean landscape as we knew it in the last 20 years. There's a law authorizing biometric authentication on airports that provides a clear framework for the police to use this kind of tool. There's specific telecommunication regulations regarding identity verification requirements through biometric systems as well. And in practice, I would like to close saying that these norms usually enable the processing of biometric data on those very specific cases and limit the purposes for which the data may be used. But everything else, security, proportionality, transparency, respect for the data subject rights remains covered by this new personal data protection law.
Perfect. Thank you, Paulina. Very interesting. So I leave the floor now to Manuel.
Thank you, Ceci. Hi, everyone. Okay, let's talk a little bit about Uruguay. In Uruguay, the use of biometric data operates under a strong regulatory framework, the law 18331 and its amendments classify biometric data as sensitive data requiring enhanced safeguards. The national authority, URCDP, oversees compliance and generally mandates a data protection impact assessment before deploying any biometric system, okay? Uruguay also follows international standards, as for example, the Europe's Convention 108 Plus, reflecting a high level of alignment with global data protection regulations. And the main challenge in our country is make a balance between individual rights and innovation. Biometric data is unique, so any branch can have permanent consequences. And the common uses here in Uruguay of biometric data include digital identity, access control in financial services, healthcare services, and government procedures. And one more thing, in Uruguay, there is a big public debate about facial recognition in public security, because it demands transparency and proportionality. So there is here a big debate between at the government and with the people.
Thank you, Manuel. I'm going to talk about Paraguay now. So Paraguay has recently taken a decisive step toward a modern personal data protection framework with the enactment of the law 7593 from 2025. This law is on personal data protection and aligns our country to international data protection standards, finally. Although this law does not regulate biometrics in a chapter, this biometric data clearly falls under the category of sensitive data, meaning that they are subject to enhanced safeguards, stricter legal basis, and higher compliance expectations. So this new law follows a risk-based and an accountability-driven approach, requiring organizations to, first of all, justify the necessity of biometric processing, then the application of the principle of proportionality, and also the implementation of technical and organizational security measures, and the conducting DPIAs when processing involves high risk processing, and which is typically the case of biometric data. So another important element is the upcoming creation of an independent data protection authority, which will likely play a key role in issuing guidance and interpreting this biometric use in the practice, right? So summarizing, Paraguay has now a legal framework capable of governing this biometric processing, but the implementation, regulatory guidance, and enforcement will be critical, and if it is used responsibly in the coming years. So now I leave the floor to Isaac. Thank you.
Thank you very much, Cecilia. And first of all, just let me to thank the organizers for all these sessions, and particularly to invite us to this panel. It's great to be with all of you. Well, I will mention first Mexico. I mean, as the jurisdiction where I'm right now posed. In Mexico, it is, as in the most of the countries in the region, in Latin America and the Caribbean, the biometrics, it is in a more general understanding under the framework of the very well placed and very implemented and very known national data protection law. Which is relevant right here, as it was mentioned by Paulina and Manuel and yourself. It is biometrics considering only data. I mean, the element of data. Nevertheless, this general data protection law doesn't cover elements related to the technology. I mean, the technology behind the creation and the interaction and storaging of the biometrics. So what is seen recently here in Mexico, it's also some concrete developments, but I will say sectorized developments, like sector by sectors. And for instance, right there, considering banking and finance institutions and regulation are more developed in those lines, because the technology, the banks need then to keep all this data, biometrics, under the standards and the elements considered secure and protected, are more developed, more detailed than other sectors. Recently, as is in other countries, as it was mentioned also, we have had here in Mexico some discussions because of the advancements of some concrete laws, concrete regulations, allowing, for instance, public safety institutions to access to biometrics because of the judicial processes, because of the investigations, because of all the elements related to law enforcement. Of course, right there, the key element, I do believe, is understand the balance between accessing to this information and keeping, of course, under the framework of the data protection in general, and particularly with the elements sector by sector. And more recently, some discussions also related to digital identity, which I think is now an additional layer to the discussion on biometrics in general. Here in Mexico, the recently created agency for digital transformation, they have enhancing many systems, including the possibility to have a new national digital identity, where biometrics, I mean, it's the same identity we do have, but with additional, I mean, the photo and then some digital footprints, etc., etc. So these are recent conversations. Nevertheless, there is no a very single one element or regulation basically ruling all what biometrics and, again, the technology behind biometrics needs. If you allow me, beyond Mexico, I just wanted to share a couple of elements or ideas with regards to more international and broader conversations. And right there, I do believe, even when biometrics and the discussions to regulate all this is not new, sincerely, which is clearly new, is biometrics as a new borderline conversation. And that borderline conversation is, from one side, included as a topic of data protection, of course, and privacy discussions, but as well as cybersecurity and security by design concerns. And right there, some consideration on the advancement of ethical and responsible use of the technology has been taken into account at the international level. And for instance, recent discussions at the United Nations and other international organizations, multilateral organizations, had put on the table this consideration as a hot topic to consider emerging technologies, particularly associated to critical infrastructure and blockchain, for instance, as elements related clearly to biometrics advancements. And right there, I only add to consider also some recent international standards. For instance, the ISO, the International Standard Organization, developing the ISO standard related to biometrics more recently last year, with aims not only to consider the data, but actually the architecture of the systems of biometrics. So I will say that it will be good that our region in Latin America, to look at those very recent advancements, also to consider not only the data itself, but actually the architecture behind.
Thank you, Isaac. Very, very interesting what you mentioned. And now I want to go to make some questions to our speakers. Paulina, you are first. And the first question is, why do biometric data require stronger safeguards than other types of personal data?
When we discuss why biometric data requires these stronger safeguards, the explanation, the initial explanation at least, is fairly intuitive, right? Biometric data cannot be changed. If a password is leaked, we can change it. If a card is compromised, we can block it. But if it's a person's face, my fingerprint, my iris, if that's exposed, there is no possible replacement for that element. That permanence and the impossibility of renewal mean that any security incident can have irreversible effects on a person. And this by itself justifies a much higher level of protection. But also, biometric identification is unequivocal. My digital print only identifies me, no one else. You would usually need more than one piece of data, non-biometric data, to associate it with an individual. Paulina Silva, lawyer, Chilean, in her 40s, several pieces of information, but not with biometric identification. Another key factor is that there is a risk of discrimination and bias. Biometric systems, like most software, have error rates. But these errors, the errors that may arise in the processing of biometric data are far from trivial, because they can result in arbitrary discrimination related to gender, to age, to phenotypic characteristics of the data subject. And this becomes even more serious if the system makes automated decision. And for that reason, safeguards must be significantly more robust and demanding than regarding non-biometric data. And also closely related to this is the fact that biometric data enables inferences. So from the analysis of a face or an iris, it is possible or it's easier to infer things such as the approximate age, emotional state, behavior patterns, even health indicators. And this, of course, opens the door to secondary uses and data processing activities that fall entirely outside of the data subject's expectations. There is also an increasingly relevant risk in today's public debate, which is the potential of biometric technologies to enable mass surveillance. Technologies such as facial recognition makes it possible to identify individuals in real time, even without their knowledge, even without our knowledge. And this not only affects privacy, it impacts freedom of expression, the right to protest, the ability to move out anonymously. It compromises democracy at the end of the day, or it may compromise democracy at the end of the day, among other rights and freedoms. And so for this reason, regulation must necessarily be stricter and more protective regarding this specific type of information. When we consider all these factors together, permanence, potential discrimination, inequivocability, inferential capacity, and surveillance risks, it is fairly easier to conclude that biometric data requires reinforced safeguards.
Perfect. Thank you, Paulina. And now I'm turning to you, Manuel. And can you tell me what are the risks organizations have when implementing biometric systems? Manuel? Do you hear me?
Yes, now yes.
Okay, perfect. There you go.
Okay, yes, of course. In Uruguay, implementing biometric systems carries several significant risks that organizations must handle carefully. One of those risks is the legal risk, since biometric data is classified as sensitive under the law, as I told before. This means organizations must clearly justify the need for biometrics. They have to conduct mandatory data protection impact assessment and register the database with the URCDP. Failing to do so can result in sanctions or legal claims. The other risk is the security, of course. If biometric data is leaked, a breach can create permanent identity risks for individuals and serious reputational damage for the organizations. And there is also a risk of disproportionate or unnecessary use, especially when biometrics are implemented without really necessity or without offering different alternatives. Other risks are technological errors or bias in facial recognition, reliance on external vendors who may process data abroad or under weaker safeguards, and ethical and reputational risks. For these reasons, implementation of must always be proportional, transparent, and supported by strong security measures.
Are you there, Ceci?
Ceci?
I'm gonna jump to the next question for Isaac.
Yes.
So Isaac,
Sorry.
Yeah, I
It was
can.
my internet. Now I'm back. Sorry. So I'm turning
all
to
right.
you, Isaac. Do you hear me? Yes, right?
Yes,
And
don't
I'm
worry.
asking, yeah, I'm asking the same question. What are the risks organizations have when implementing biometric systems? And also, I would like to add, how can compliance requirement be embedded into operational security and reputational risk control rather than treated as isolated legal task?
Sure. Thank you very much for the question. And I'm completely aligned with Manuel's comment and the points he put on the table. But I will add also that considering risks beyond the legal risk and of course the cyber security and the technology-based related security, the reputational side, the elements related to reputation, the communication, and the way to communicate inside the organizations and beyond the organizations, that this concrete organization is capable to storage and to protect and to manage biometrics, it is key. So as part of the risk-based approach, and thanks for the question, because basically from my point of view, the risk-based approach is a key element then to advance in the adoption of biometric system or in the updating basically also biometric systems. Under this risk-based approach, I will add this layer of reputational communicational element. Sometimes when you face some breaches, data breaches, it has been mentioned, it is really clear that it is the organization, but in particular the data thread. In this case, the element of the continuity of the processes and to manage the crisis needs additional elements related to reputational responses and communication responses because of the sensitiveness of the data, of all biometrics. Storaging the data, biometrics data, also it's a key element to consider from the risk-based approach. And when I say storaging, is both like a storaging from a digital domain understanding, but also storaging because in the end, all this data are storage in data centers, localized in a very concrete jurisdiction, etc. So having clear idea, not only getting the technology, not only getting the service, the software, but actually knowing perfectly which is the last place, though that those places in concrete jurisdictions, etc. It is key to consider the development, updating, and advancement of biometrics systems. And from a compliance approach, of course, responses are needed not only, and measures are needed not only from from a very clear legal approach, but also from a more security approach, and I will say like an inter area, like a multidimensional understanding of compliance, where also scrutiny from relevant stakeholders, not only authorities, but investors, customers, etc., are increased. I mean, scrutiny, of course, is one of the elements that once you have biometric data, it is clearly increased. So monitoring that kind of scrutiny as part of our compliance approach, it is also recommended. And particularly having a very well structured and very well documented track to manage any kind of crisis related to biometrics is part of the elements of not necessarily compliance, but enhance compliance, like going beyond what we are commonly mentioned as compliance. I will add those layers in this case.
Excellent. Thank you. I believe Paulina has a question for me now.
I have a question for you, Ceci.
Okay, great.
So, let us know from a risk management perspective, what safeguards do you think should be considered non-negotiable?
Yes, so from that perspective, I believe there are certain safeguards that should be considered, as you mentioned, not negotiable. One of that is the lawful basis and purpose limitation. As we were mentioning, every processing activity must have a clear legal basis and a very defined and legitimate purpose, because data should not be collected just in case, it should be collected only on those bases. And there's also the data minimization by design, which is the collection of data that is strictly necessary. If the purpose can be fulfilled without this sensitive data or biometrics data, that option should always be the one that is preferred. And also, interesting topic is the privacy by design and by default, which I think we have a question that we will answer at the end of the panel. And that I'm just saying that these safeguards must be embedded, as mentioned Isaac, from the beginning, not at later in a late stage of the product or service. And these systems should be considered or configured to operate with the highest privacy settings by default, as their name says. And also, I believe that the risk assessments before the deployment is very, very important, because this high risk processing should always undergo with a prior impact or risk assessment to identify and mitigate potential harms before going live. And also, as you mentioned, the robust security measures that may include encryptions, access controls, logins, and regular security testing, which is I would like to add that security is not only technical, it's also having clear internal policies, also staff training, which is very, very important also, not only the technical part, which is of course very important, but also the other documented things that is not that very easy to see, but we lawyers do know that exist and they're very important. And just finally, one comment more, it's about transparency. Individuals must understand what data is being collected and for what purpose, and how these decisions should be or will be affecting them, especially when these systems are involved. And also because of the data, as Paulina mentioned in her examples, it's very, very important because it identifies ourselves. And there's no another Ceci yet, at least. So very, very important. And just the last comment, the human oversight, which I believe it's very important. Human must review this built in the process, which I know this is an AI era, but do not forget that we still have control and have the chance to have this oversight as human beings. So that's, I think, I believe that's it. And I think we have just like 5 minutes. So I would like to just the final round and final comment, and ask you, Paulina, about the best practices and uses cases in your jurisdiction regarding, of course, the biometrics and risk management. And then we will answer the questions.
All right.
Thank
So
you.
in anticipation of I'll try to make it short and sweet. In anticipation of the entry into force of our new data protection law, we're seeing good practices in the processing of biometric data, and we're truly seeing that they're making a real difference here in Chile. We have a lot of work as privacy lawyers, which is good news. We're seeing organizations that are not merely trying to comply, but are instead seeking to anticipate these strengthened standards that the new law will require, and they are incorporating practices like conducting privacy impact assessments, documenting specific controls, including or structuring alive privacy risk matrices, supply classification criteria. We're seeing that a lot. That classification criteria for vendors that will process personal data, which is conducted, of course, ex ante and not ex post. More robust security policies. So altogether, these developments reflect a very important culture shift that we thought would never happen, actually, after all that long discussion before Congress of the new law. And this shift relates to more responsible design from the outset and a preventive approach to risk management. In this context, recent Chilean use cases show how this logic is being applied in practice and what are those challenges. For example, I was referring to the Undersecretariat of Telecommunications that implemented a regulation requiring telecommunication companies to verify users' identities through biometric data to prevent fraudulent number portability and identity theft, while at the same time imposing high standards for data protection. Regarding airports, again, a specific law authorizes the investigations police to use biometric technology to verify the identity of passengers on domestic flights. And this illustrates and has illustrated common tensions. While the security purpose is legitimate, questions have arisen regarding the proportionality, the necessity of using multiple types of biometrics, what enhanced security measures are required, are they actually being applied, given the sensitivity of this processing? Finally, the biometric registration process for foreign national in irregular situations led by the immigration authority, which is becoming a large issue in this country, and also led by the investigations police, shows how these systems are being used for public policy and national security purposes, reinforcing the need for strict controls when processing biometric data. So taken together, these examples show a pattern that begins to be somehow consistent. Strong biometric projects stand out because the technology genuinely adds value. There should be a clear justification for its use. Risks are beginning to be assessed prior to implementation, and robust measures of security, proportionality, transparency are starting to get adopted. And this conversation is just beginning to take shape in Chile as well, how to use biometrics with risk-based, rights-based, and a responsibility designed approach.
Perfect. Thank you, Paulina. Great way to end these discussions, and we will have some questions. So I'm reading the first one. It says, how can companies effectively conduct risk assessments for biometric systems, especially when these technologies evolve faster than regulations? Yeah, perfect. You do it, please.
So I think these are just suggestions, right? Because it's a very hard questions. I would think that there are different sort of verticals in which you could work. You should consider dual risk lens, technical and societal, because biometrics require a look beyond cybersecurity. So from the technical point of view, accuracy failures, model drifts, vendor risks, look at that part of the biometrics. And from a societal point of view, check your bias, consent problems, surveillance concerns, which also relate to the legal perspective, right? The risk assessment should be a continuous exercise, not just a one-time exercise. And in the world of compliance, I see this happening more and more, where compliance sort of from a company, it has the risk of becoming just, a checkbox, an infinite amount of checkboxes. If this risk assessment is not continuous, it'll be as useful as the time that it's valid for, and then you'll have nothing, right? The biometric models also evolve very quickly, so you should use a rolling cycle where you identify data flows, you analyze the threats, you mitigate those threats, and then you keep monitoring, and then do it all over again. You should use established frameworks and build also this. I know this sounds like a lot of lip service, but you need to build cross-functional governance, right? To include security, privacy, legal, engineers, ethics, operations, because it just like everything else in the privacy realm, it is just very transversal. The impact within the companies, it's truly transversal, and then you're not off the hook if you're just talking to marketing, or if you're just talking to legal, or just talking to the CISO. This is what I can come out with for this question.
Excellent. Thank you, Paulina. Do you want to add something, Isaac? Or we're just going to the next?
Yeah, sure. No, absolutely. I agree with Paulina. And I will say that perhaps it's also relevant to consider. Sometimes we talk about a biometric like in singular, like a biometric system, but we do need to take into account in any compliance effort, any risk assessment, that we are in front of biometric systems in plural and biometrics in plural, which is relevant then to consider in those risk assessment, in those elements related to compliance, interoperability. I have been involved in many crises, managing many crises related not necessarily to a breach, but a problem of interoperability. So when introducing new technologies, when transitioning from a more technological level, sometimes we are very aware, and we take into account all the legal elements, but the technology side, it's not necessarily with the same detail. That is why I will emphasize, consider biometrics both always like data and all the related needs to protect the data, and also as a technology or technology-based approach. Then having these two elements, we will have a robust risk assessments and enhance compliance efforts.
Excellent. So we ran out of time. So thank you very much for participating with the questions, and also you, the speakers. Thank you for being here.
Thank you.
And hope we have a next session, virtual session again soon. And thank you very much for everything.
Pleasure to see you guys. Thanks for everything.
Nice to see you. Bye-bye.
Bye-bye.
Bye, Alessandro.
Thank
you to all our speakers for being with us today, also for this session that was again extremely interesting and insightful, very practical in this case. So thanks a lot to you all for your efforts also in being here together with all the other panelists. And I also wanted to thank our audience for being with us today along this very long but insightful event. We went from more general to more practical. I like to conclude with another little video of privacy rules before leaving you all. But once more, thanks to the entire audience. I think this is going to be the last live event of 2025 from Privacy Rules. So I also take the occasion to wish happy season on holidays to all the members of the Alliance that joined us today, the ones that didn't, but are great members, and also the audience. So all of you being together with us. Looking forward to the next event. Looking forward to be connected with many of you. Feel free to reach us to know more about the Alliance and our services. See you to the next one. Bye, everyone.
Updating privacy policies across multiple countries shouldn't feel impossible. But with regulations evolving constantly, new requirements emerging every month, and each jurisdiction demanding something different, even the simplest policy update becomes slow, fragmented, and costly. Most organizations spend weeks, even months, trying to align global policies, only to end up with inconsistent documents that fail to meet local expectations. When compliance becomes unclear, risk increases. The Privacy Rules Global Policy Revision Service solves this challenge, We deliver a coordinated cross-border methodology that adapts to any sector, including fast-moving, AI-driven industries where regulations are changing faster than ever. Our global experts collaborate to ensure every policy update is accurate, aligned, and fully compliant with local laws. No more conflicting versions. No more overload for your internal teams. Just clear, consistent, globally harmonized policies delivered efficiently. We streamline the entire process. Flexible coordination across jurisdictions, centralized invoicing, shared workspaces for seamless version control, and strict confidentiality at every stage. Everything you need to revise policies efficiently, all in one coordinated service. Privacy Rules, your global partner for seamless cross-border policy compliance. Simplify your global policy revisions. Contact us today.